Let's take a look at an introduction to agency rulemaking. All agency actions can be classified as executive, quasi-judicial, or quasi-legislative. Because agencies are executive bodies, in most instances they perform executive functions. However, when an agency acts like a court, even though it isn't a full court, it's said to be acting in a quasi-judicial capacity. Generally, agency quasi-judicial behavior is referred to as adjudication. When acting in its quasi-legislative capacity, this behavior is referred to as rulemaking. The distinction between adjudication and rulemaking is important because the APA imposes different responsibilities on agencies depending on which function is performed. Rulemaking is the process whereby agencies establish law to implement or perform a statutory duty. A rule is designed to implement policy and describe the practice requirements of an agency. It's sometimes hard to distinguish between rulemaking and adjudication. The APA attempts to distinguish decisions and orders from rules and regulations by stating that if an agency's action is intended to have future effect, it's a rule. In addition, rules implement, interpret, or prescribe law or policy, or describe the organization, procedure, or practice requirements of agencies. Said another way, if an agency establishes a policy that's to be followed from that date forward, or issues a rule explaining how it will perform some function, it's created a rule. Adjudication is a process that investigates, declares, and enforces liabilities. That's the purpose and end. Legislation, on the other hand, looks at the future and changes existing conditions by making a new rule to be applied thereafter to all or some part of those subjects of its power. Generally, adjudications involve individual claims, whereas rules are directed at large groups. Adjudication can result in an immediate sanction against an individual. A rule cannot. An adjudication to enforce a rule must be made before a person or company may be sanctioned. There's another significant difference between rulemaking and adjudication: due process. Generally, agencies are free to make rules without conducting hearings. That's not true of adjudication. Due process requires the government to provide some form of notice to persons affected and the opportunity to be heard. Most people likely think of the U.S. Congress and their state and local legislative bodies as the source of most law. However, that's not true. Today, the bulk of law is made by agencies, not legislative bodies. Congress may enact a couple hundred laws in a year, whereas the total number of rules promulgated by agencies is in the thousands. Several presidents have attempted to reduce the size of the federal administrative state, all without success. Many of these regulations affect only a small number of people and businesses. Others regulate more broadly. In aggregate, the total regulations of federal, state, and local agencies greatly affect the lives of all people. Accordingly, an understanding of administrative discretion to make rules is an essential aspect of administrative law. There are two types of rules: legislative and interpretive. Legislative rules can be further divided into those that are procedural and those that are substantive. As a general proposition, a legislative delegation of authority carries with it an implicit authority to establish procedures necessary to enforce and implement the agency's delegated mandate. Agencies are normally bound by their own procedural rules, as are those who deal with those agencies. The other form of rule is substantive. These rules affect the rights of individuals and are functional equivalents of statutes. There's no inherent authority to promulgate substantive rules. Congress must delegate this authority. The Supreme Court has found, however, that the authority may be implicit in the agency's mandate from Congress. That is, the authority may be found in the absence of a statute expressly granting it, as long as it's clear that Congress intended for the agency to have the authority to fill in the gaps. If promulgated properly, such rules have the effect of statutes. They require or prohibit actions and may impose penalties for violations for their mandate. Although the rule must be consistent with the agency's enabling statute, it may declare something that the statute has not. The APA uses the phrase substantive rules rather than legislative rules. A court may not substitute its judgment for that of a substantive agency. That is, a reviewing court cannot declare that a better standard or procedure must be used. A substantive rule has the force and effect of law. Interpretive rules do not declare something new. They do not fill in gaps of legislation. Rather, they represent an agency's interpretation of a statute's meaning. Interpretive rules are used to inform the public of how the agency intends to implement and enforce a statute based upon its understanding of the statute's meaning. An agency may issue an interpretive rule even though Congress delegated no authority, expressly or implicitly, to do so. Whether the rule is interpretive or substantive often depends on whether Congress has given the agency the authority to promulgate rules. If rulemaking authority has been granted, the rule is more likely substantive than interpretive. Unlike substantive rules, interpretive rules do not have the force of statutes. Courts may interpret statutes on their own and are not bound by agency interpretations thereof. However, courts often give great weight to agency interpretive rules and value agency interpretations. Rulemaking is the administrative equivalent of the legislative process of enacting statutes. Agencies are not subject to stricter constitutional requirements in rulemaking process than legislatures are in enacting statutes. Because legislatures are not constitutionally required to conduct hearings or provide notice of proposed legislation, neither are agencies. The process that must be followed by federal agencies when making rules is prescribed by the APA. An appreciation for the APA's historical context aids in understanding why Congress chose to regulate rulemaking in the way that it did. The APA establishes 3 procedural forms of rulemaking: formal, informal, and exempted. Federal law also provides for negotiated rulemaking. Remember that each state has its own rulemaking requirements, and they often differ significantly from the federal formal versus informal model. Formal rulemaking is the most time-consuming, expensive, and procedurally involved method of rulemaking for agencies. Formal rulemaking is required only when mandated by Congress in a separate statute. The APA alone never mandates formal rulemaking. Under the APA, informal rulemaking exists by default. If a statute does not require formal rulemaking, then an exemption does not apply. Then informal rulemaking may be used. 3 simple requirements are imposed upon an agency using informal rulemaking. First, as for formal rulemaking, the agency must publish a notice of proposed rulemaking, normally in the Federal Register. Second, the agency must give interested persons the opportunity to participate in the rulemaking process. No trial-type hearing is required for the agency. Rather, interested persons have the right to submit to the agency written comments containing data, views, or arguments. Although not required, agencies occasionally permit interested persons to testify orally. Finally, the APA requires that the agency issue its final rules with a concise statement of their basis and purpose. This requirement is not as strict as the findings requirement of adjudication and formal rulemaking. However, a rule may be invalidated by a reviewing court. Agencies may be delegated the responsibility of establishing rates for an industry. This function is normally legislative in nature and therefore free from due process concerns. However, not every instance of rate making is legislative. It is possible for an agency to be engaged in what amounts to an adjudicative function when setting rates. When an agency sets a rate that applies to an industry that has many procedures or providers, it has made a rule of general applicability. For these decisions, legislative-type facts are relied upon. Information about an industry without particular attention to one member of that industry is legislative. It's different when there is only one member of an industry and an agency sets its rate. If an agency focuses on one particular individual or entity when making a decision, whether that decision is characterized as a rule or as an adjudication, it's conducting an adjudication. If there's only one member of an industry, as is often true of gas and electric companies, an examination of that industry is an examination of a single business. Due process applies to adjudicative proceedings. Therefore, if there's only one member of an industry, that entity is entitled to due process in rate making. When an agency engages in rate making that is legislative in character, it must comply with the APA's rulemaking requirements. When an agency engages in rate making, it must comply with the ADA's adjudication and due process standards. Most revenue-raising law comes from legislative enactment. Taxation by Congress creates no due process concerns because people have control over who sits in Congress. Congress gets its authority to govern from the governed. Further, elected representatives are presumed to keep the citizenry informed on notice of legislation. However, the authority to impose a tax may be delegated by Congress to agencies. In such cases, the decision to tax is not being made by elected representatives. Therefore, when administrative bodies engage in revenue-raising rulemaking, due process requires that notice to the public be given and that taxpayers be provided an opportunity to be heard. In addition to due process concerns, the delegation itself must give the agency an intelligible principle from which to act. Agency officials possess considerable discretion in rulemaking. At the front end, agency officials decide in most cases whether rulemaking is needed at all. During rulemaking, agencies' officials decide what processes must be followed, what rules govern these processes, and the timing of various stages of the process. In the end, it's an agency official who reviews the evidence, finds the facts, and drafts the final rule. However, this authority is not unchecked. All three constitutionally created governmental branches play a role in controlling the authority of administrative officials in rulemaking. The rulemaking procedure is set forth in the APA and is intended to limit the discretion of agency officials by mandating minimum rulemaking procedures. Congress can withhold from or otherwise limit the authority of an agency to make rules. Congress controls agencies in various ways. Of course, the greater the authority Congress is in the creation, definition, and funding of agencies. Defining and refining its delegation of rulemaking authority is also important to control. Congressional delegation of rulemaking authority must be accompanied by an intelligible principle, a requirement aimed at limiting the policy discretion of the receiving agency. In addition to controlling delegations for rulemaking authority, Congress is often attempted to control rules themselves. The President also plays a role in controlling agency rulemaking. The courts play a role in checking agency discretion through judicial review of agency rules. Finally, agencies exercise self-control.